Welcome to Early Returns, hosted by Jan Barron, a partner of Holtzman Vogel. This podcast examines law and politics and seeks insights from political players in elections, lobbying, media, and the law. Now, let's join our host, Jan Barron.
Welcome back to Early Returns, a podcast about law and politics. I'm your host, Jan Barron. I'm a partner at the law firm Holtzman Vogel. Our producer is Jody Mayer-Piazza. The first Monday in October is the traditional beginning of a new Supreme Court term. This week, the 9 justices began hearing cases that involve our constitutional rights and shape U.S. law. Each term, the Supreme Court seems to be tackling the big issues, including abortion, gun rights, voting rights, affirmative action, and the checks and balances of the constitutional powers of Congress, the White House, and the Judiciary. The last term was significant for many reasons, but perhaps most memorable for the court's decision that overturned the 1973 case of Roe versus Wade, which established a right to abortion under certain conditions. In the past 50 years, there may not have been a more important justice on the Supreme Court than Sandra Day O'Connor. She was appointed by President Ronald Reagan and retired in 2005. She regularly was the deciding fifth vote on important cases, including abortion cases. She also was the first woman to serve as a justice on the court. Justice O'Connor today is 92 years old and resides in Arizona. To talk about the justice and the Supreme Court today, I am fortunate to have as my guest Evan Thomas. Evan previously appeared on Early Returns to discuss Watergate, journalism, and President Richard Nixon, who was the subject of Evan's book, Being Nixon. Evan is the former Washington bureau chief of Newsweek magazine and the author of 9 books. His most recently published work by Random House is the biography of Justice O'Connor entitled First. I also am lucky to have as a guest Osceola Freer Thomas, better known as Oscie Thomas. Oscie works with Evan, conducting interviews, editing, and researching. Evan and Oscie worked collaboratively and did so especially on the O'Connor biography. The Thomases met at Virginia Law School, and unlike Evan, Oscie actually became a member of the bar and practiced law. They are a husband and wife team in publishing and in life, with 2 grown daughters and 2 grandchildren. Oscie and Evan, welcome back for you, Evan. Welcome, Oscie, to Early Returns.
Hi, Jan. Great to be here.
Thank you.
Well, everyone knows you, Evan, because you were on this program once before, and we have extensive biographical information about you, but not so much about Oscie, who's here for the first time. Why don't you tell our listeners, Oscie, a little bit about where you grew up and what you did before starting to help Evan with his books?
I am from California. I grew up in Los Angeles and went to Stanford University for my undergraduate degree. And that's relevant because Sandra O'Connor went to Stanford. And that just struck a chord with me right away. And then I went on to UVA Law School, where I did meet Evan our first year. We got married that year. Then I went to New York. We both went to New York, and he became a journalist. And I went to a law firm called Donovan Leisure for 6 years in New York and then DC, and then to AT&T for 20 years. And in 2000, I retired from AT&T and started working on Evan's books, as you mentioned, as editor. And I love editing and researching and just talking through these wonderful topics and wonderful subjects Evan has been working on for a long time now.
And how did the O'Connor project get started for you too? I mean, what triggered that?
I was approached by O'Connor's editor and publisher, Kate Medina at Random House, because O'Connor had written a pretty good memoir of growing up on a ranch called The Lazy Bee. And of course, Random House wanted her to do her full memoirs, and she was interested in it. And so I was brought in as a possible ghostwriter, and I spent a day with her, but I could see that she was interested in being remembered, and she wanted to leave a legacy, but I could see that she was not really comfortable about telling her own story. And then I didn't hear anything for a couple of years. And then I heard from my agent saying, well, this project's back on, but this time you'll be writing a biography of her. You'll get cooperation from the family, but it's a biography. It's not authorized, and this is important to publishing. It's not authorized. Authorized means that the family has control, and it was important to me to be independent. So the O'Connor family has no control over this. They did cooperate a great deal, and they're in one area. I did have to make a deal with them, a perfectly reasonable deal, because in O'Connor's papers is the diary of John O'Connor, her husband, 20 years worth. Pretty personal. And I agreed that if I quoted from that, I would clear those quotes. So that was the one area where the family did have some control. It worked out fine. They didn't object to anything. But otherwise, it was I worked closely with them, but the product was mine and was Ossie's too. It's a collaborative work, and it's a biography. And there were lots of twists and turns, of course, in the doing of this, but that's the basic start.
We had access not only to her papers at the Library of Congress, which are still closed, but also her papers at the Supreme Court, her personal papers and her personal journal. And so we were privileged. We just felt so fortunate to have this project.
And did you both meet with Justice O'Connor, or was that just Evan who had those meetings?
We both did. I met with her 3 times, and Oscie was there for the middle time. And I went down to see her in Phoenix. And when I arrived, it was a bit of an audition. I mean, this was not a done deal. But when I arrived, I learned that she had early Alzheimer's. And it was never fully diagnosed as Alzheimer's. She had dementia, probably Alzheimer's is the correct diagnosis.
And when did that diagnosis occur? I mean,
this is 2016 when I saw her. 2014 was when she got the diagnosis. Mm-hmm. She was still going pretty strong. I went to a dinner that night with her, 150 people there. She worked the crowd. Justice Souter was there. They held hands. He called her Toots. Pretty sweet scene. But, she was pretty in the game, but not 100%. And, this is obviously going to be an issue. And it was clear for me that when I talked to her, both because she had Alzheimer's, but also because it's just her nature, she didn't want to get too deeply into the cases. We did that a little bit, but more our conversations were about her life and her family. And she was able to talk about that several times with me, with Oscie, and then I went back and spent a day with her a third time. We had to be clear with her son sitting there that she knew what we were doing here, and she understood the terms of it. And importantly, very importantly, she wrote a letter to her colleagues on the court and to her friends and to her law clerks asking that they cooperate in this project. Now, that's very important in any situation, but especially important in the Supreme Court because there are all sorts of rules about, or unwritten and written rules about what you can say and what you can't say. And that all had to be sorted out.
This book is very unusual, not only in terms of its subject, Justice O'Connor, who had a really interesting life early on and professionally and on the court, but you perhaps the only journalist who really got a letter of introduction to all the other justices. Now, were there some who refused to talk to you?
Yes. And some who, particularly Justice Kennedy, who I indicated that he might and then didn't. Justice Kennedy, I believe, is writing his own memoirs. Maybe he was saving it for that. I don't know. But and I knew him a little bit, but he did not participate. The ones who were colleagues, Justice Stevens, who was there the entire time that she was there, was wonderful and talked to us a couple of times. And Justice Ginsburg, who was there with her for half the time, she talked to us at length twice. And Justice Breyer, who was the closest, I would say the justice who was closest to her on the court, spoke to us. And so that was very helpful. Then there were a few who arrived after her. The Chief Justice spoke to us. He was pretty funny, actually. We can talk about that later. Justice Kagan was very eloquent, and Justice Sotomayor. And then, very importantly, Clarence Thomas. Clarence Thomas was hard to get at. He resisted for a long time. We ended up going through Senator Danforth, who was a close friend of his. He finally agreed to do it, and he was great. I learned a lot from him about the way she worked to keep the court together. She and Thomas and O'Connor did not vote together often, really almost at all, but they not in big cases. But he told me a very affecting story about how she worked. And that it was this, that when he came on the court, he said, I felt hammered because the Thomas hearings were just terrible. And he was kind of sulking in his tent. He wasn't talking to the other justices. And she walked with him after conference. She would walk with him down the hallway to his office. And she would say, Clarence, you got to come to lunch. He didn't want to come to lunch and he resisted it. And finally she said, Clarence, you got to come to lunch. And he said, okay. And he said that changed everything for him because they don't talk cases at lunch, but there's an important social element to here. They would talk about books and movies and all that, their grandchildren, but he became part of the group because of her. And he said to me, she was the glue. We were a family. We were a dysfunctional family, but we were a family, and she made it so. And that was an important role for her.
Well, somewhere in your book, I think you quote somebody about the nature of the Supreme Court and the 9 justices. I mean, those of us on the outside would think of the Supreme Court as an institution, and you got 9 people. They're all in the same roof and so forth. But professionally, they were described in your book by somebody as basically 9 solo practitioners, right?
Justice Powell, he was one of the ones who tried hard to overcome that. I mean, he was a rare case of somebody who would go to the chambers. They don't even go to each other's chambers, except on rare occasions. Now, there are exceptions to these. It's not uniform. But by and large, they communicate by memo. Now, there's a reason for that. That sounds a little cold, but, the law is supposed to be precise. And you can have a conversation. You can think you agree, but you don't really agree, and you can't really remember what the hell you said. By memo, it's not, there it is. And we're using words of art, and they do. Their memos to each other are quite technical, often written by clerks. Are quite technical, and they use words of, legal terms and words of art. That's how they communicate. Because, of course, in their opinions, when they're laying down the law, it has to be in words that are familiar and understood and that they all agree on.
Was Justice O'Connor very successful in attracting all of her colleagues to a luncheon on a regular basis?
Supreme Court has its own dining room, and they have a scheduled lunch. Only a couple of the justices were going. And she likes to use food as a way to gather people. And so she got Thomas, to use one example, to come to lunch by walking with him and saying, you've got to come to lunch. And finally he said, yes, ma'am. And off he went. But by, soon after she started her campaign, the justices were all going to lunch. And they would talk about the theater, and they talk about books, and they talk about their families, and they would not talk about cases, but they would get to know each other.
And Sotomayor told us that she would just come sit in your office.
Yes.
If you weren't going to lunch, she's a pretty direct person and forceful. She would just show up in your office. Okay, we're going to lunch. And it went, I think when she arrived there, I think 4 of her 8 colleagues were going to lunch. There was a lot of tension on the court because this was right after the Brethren. And the justices didn't trust each other. They didn't know who leaked to Bob Woodward and Scott Armstrong. And there was a lot of distrust. Also, they were getting older and they just didn't want to go to lunch. And it took a few years, but she enforced mandatory attendance. Yeah. And they got to like it.
And do you have any sense whether that tradition has been maintained after Justice O'Connor left the court?
I would be surprised if it's as successful as it was in her day, and certainly now after the leak of the Dobbs case.
Justice Thomas said as much in a speech a few weeks ago or a couple of months ago. He talked nostalgically about her period.
Yes.
And he used that line about, we're a family, a dysfunctional family, but a family. He used that line with me when I talked to him. And he indicated that although he liked the old chief, Rehnquist, he was less forthcoming with his warm and fuzzy feelings about the current chief. And the suggestion by implication was that things have broken down a little bit. It's not as warm and fuzzy. Well, there was a long period where there was no change on the court from 1994 to her leaving. So 11 years, I think it was.
Right.
The same cast. And they had a chance to get to know each other. There's been a lot of turnover since then.
Mm-hmm. There's a lot in your book about Justice O'Connor's childhood and upbringing. She grew up on this 2,000-acre ranch in Arizona that bordered New Mexico. When it came time to think about going to high school, they had to send her to El Paso to live with an aunt. And she wound up going to Ossie's college at Stanford when she was just 16. I mean, so she was precocious. She grew up in a very Western rugged environment, obviously, seemed to be somewhat self-reliant, going away to school at an early age. Even if you're living with your aunt, you're pretty much on your own, not with your parents. And then graduated from law school in fast order. I think, what was she, 21 or 22 by the time she graduated from law school?
Right, yeah.
Yeah, very, very young. And it was a reflection of her energy and also her intelligence, obviously. But then wound up marrying her husband, John O'Connor, going to Phoenix to start a professional life after some military tour by her husband. And there she was, eventually becoming the president of the Junior League or something like that, right? So it was an interesting progression, and she sort of...
Well, eventually she became the first woman in the country to be the majority leader of a state legislature, the Senate, the Arizona State Senate. So she arrived in Arizona unable to get a job at a big law firm because she was a woman.
Yeah. And that's similar to the experience of other women at that age, in that point in history, including Justice Ginsburg in New York. She was an East Coast person, not a West Coast person. Did Justice Ginsburg and Justice O'Connor have a rapport since they were the first two women on the court and had these similar looking experiences? Or what would you say was their relationship?
Pretty good. They were cozy, intimate friends. Scalia and Ginsburg were. They went to the opera and they had a real bond. O'Connor and Ginsburg are different in a lot of ways, culturally different and different, but they definitely had a close relationship in this sense. O'Connor was glad when Ginsburg, she was glad not to be the only one anymore. For one thing, they finally put in a ladies' room near the changing room.
It was 12 years. She was the solo woman on the court for 12 years before Ginsburg came.
There's a great collegiality moment that a couple of them, Ginsburg said, O'Connor said, you want to get an assignment from the chief to write a case, and it's supposed to be an easy one. And Ginsburg, the chief gave Ginsburg a hard one. Or an ERISA case. And Ginsburg said, what do I do? And O'Connor said, oh, Ruth, just do it, which was her way, just do it. And they struck up a bond on this. But then the touching story and the meaningful story is that big sex discrimination case, VMI case, where the issue is, does VMI, a state college, military college, have to take women? And the case is assigned to O'Connor, who's by the senior justice. I think Stevens assigned the case to O'Connor. And she said, no, I think this should be Ruth's case in conference. That never happens. Justices don't say, no, give the case to somebody else, especially a big one like this. But O'Connor said this should be Ruth's case because she knew that Ginsburg had done so much to advance the cause of women's equality. And Ginsburg said, I loved her. Loved her for that. And when they announced the decision from the bench, you could see there's a little smile. Ginsburg looked at O'Connor, and she, for the rest of her life, she was grateful to O'Connor for that. And that's classic O'Connor, is that kind of humility, confidence, but, humility to do something like that.
You've spent time with the justice and obviously a lot of time researching all these elements of her career on the court, which spans 24 years. Do you have a judicial philosophy that you would characterize for Justice O'Connor?
She disliked the idea of philosophy, of having a jurisprudence. Those are words that she kind of recoiled from. You don't find really any discussion of that in her opinions, which are very factual and willfully dull. I mean, in fact, when her clerks tried to put in turns of phrases, she'd take them out. She was a minimalist. So this is me talking, not her. And Oscie should chime in. She was a minimalist, just the facts. She believed the law should be incremental, inch along. She was very sensitive to unintended consequences from a decision. Judge Webster, the former FBI chief, said to me she was a consequentialist, meaning she was worried about the consequences of a case. But the big item for her, I'd say her philosophy, which we write about, Oscie and I write about, but really comes from a clerk that we talked to, was this idea that the court is in a dialogue with the other branches of government. This is the most important thing, I think.
And she talked about it herself in an interview with Bill Moyers.
She did. Yeah. So she did. But that was pretty singular. Yeah. One time that I could find that she talked about it.
It's in an ongoing conversation with the elected branches of government, so that if the court makes the decision, they're not saying we're the final word. They're saying to the legislature or the executive, try again, do better, bring us a better case.
Particularly on the big issues.
On the big issues.
Social issues.
They really understand, she understood that they were not elected, that they were judges appointed for life, and that they had an obligation to society to be modest.
Did she ever engage in the debate among the justices between, the originalists and the living Constitution wing of the court? How do you treat the Constitution? Do you divine the meaning of the document from 18th century lawmaking, or the amendments in the post-Civil War era, or do you take the document and try and adapt it to current times and needs for the law and society? Did she ever get into that?
No, but I can tell you the answer. She was not an originalist, for sure. She did not like rules-based. She was more of a standards-based person than a rules-based, and she didn't like rigid philosophies or doctrines that handed down a result. She didn't like that. She was much more pragmatic, but she was, nor was she a full-on Warren Court living Constitution. She was more in that camp, but certainly not all the way, especially since when she arrived, she was really more of a federalist. She wanted to give some of the power back to the states. And of course, the Warren Court was, a lot of that was taking power away from the states and giving it to federal courts. And she resisted that. She was with Rehnquist and wanted to return some of that power to state legislatures and state courts. And she did, particularly in habeas cases and criminal rights and a bunch of areas of regulation. But as time went on, she did move to the left. Various ways of measuring this. There's a famous standard or score that does this. And she gradually moved to the left and became more of a living Constitution type, I would say, or liberal. You can use these words have imprecise meaning when you talk about justices. But gradually a slight move to the left, particularly where cases involving women and children, she would see a bigger role for the federal government than she might otherwise have seen.
And that would have been true, particularly in the abortion cases. There were a couple of really significant post-Roe versus Wade cases that came up in the 1990s. There was, and 80s, I guess, there was an expectation at one time that there might be a majority of the court at that time to overrule Roe versus Wade. And how would you characterize what was going on then and what the outcome was? Because it seems to be a typical incremental step by Justice O'Connor, but also very sympathetic to some of these new rights that were created.
She and her husband did not talk about the cases. And when she became justice and the first set of cases came up, he wrote in his diary that it was possible that she would be the fifth vote to overturn Roe versus Wade. He did not actually understand his wife completely. She thought a lot about the issue. She researched it. She never talked to her friends about cases, but she talked to a few friends about their views. And we talked to some of them. And so in the early Webster case, it's a case where the court is still upholding or reversing states that are trying to impose restrictions on any deviation from the straight Roe holding. And she is willing in that case to have a restriction stand that says that public funds can't be used for abortion. And they go from there, and then Rehnquist next writes the decision, in that Webster case, where she starts to see that her view is that the Roe case adopted the wrong approach, a trimester approach that's medically improper because viability is going to be a moving line. and that the better test is undue burden. And that is initially part of her dissent in Akron. It becomes the approach used later in Casey. That's, I think, the case you're referring to. But she starts to see what the states are doing. They're imposing incremental and then more aggressive restrictions on a woman's right to abortion. And they include parental notification for both parents. She strikes that down. They include public funding, licensing requirements. She's willing to go along with a lot of that. But she has decided by then that Roe is both a law that, or a holding that now a generation of women have come to rely on. And when the Casey case comes up, it's a Pennsylvania case, and it has a lot of provisions, a waiting period, informed consent, notifications, husband, spousal consent is one of the original aspects of the law. She decides that she's not willing to overrule Roe versus Wade. She's willing to uphold some of those provisions. By then, there are more conservatives on the court, and she pulls together a Kennedy and Souter, and they come up with an opinion that becomes effectively the law of the land in 1992 that is really the target of the recent Dobbs case, if you read the Alito opinion. And she is hoping that Casey will bring in some period of quiet in the abortion wars. That doesn't really happen, but it does. The test remains the test for the next 30 years, which is significant. It's a long time. And meanwhile, the Roe case has been in place for 50 years.
I think that those cases and her involvement in the abortion debate really reflects the divisiveness of the issue itself as a matter of jurisprudence, because what has ultimately transpired is there's a majority on the court today that says there is no constitutional right to an abortion, and that the Roe case really invented a right on the basis of certain precedents involving interpretations on privacy and things of that sort. But on the other hand, it also reflects what Evan just said about Justice O'Connor, that she recognizes when things are a little off, but if there's going to be a change, it's going to be an incremental change. So she used the Casey case and the Webster case as a vehicle for modifying Roe versus Wade. So it gets changed and it goes off in a slightly different direction.
It is changed, but the bottom line is that there is a right, certainly in the early stages of a pregnancy, to abortion, and that can be circumscribed somewhat, but there cannot be an undue burden. She's not willing to turn it back to the states. She's already started to see how extreme some of the states are in terms of trying to effectively deny any right to abortion. And she's troubled, particularly interestingly, by Alito in the Casey case. She has a line in the case, spousal notification. She says, women do not lose their constitutional liberty when they marry. She dislikes this idea that women are somehow subservient and can't make their own decisions. And I think one thing she really recognizes is that the decision to have an abortion is an agonizing one for any woman. So some legislators seem to think it's a cavalier decision. That's not how she thought about it. I think she thought that all women are pro-life. It's not the pro-life versus pro-choice. Everyone is for life. And that the women who sometimes tragically decide they need an abortion, or their doctors tell them they need one, need to be able to make that decision in privacy and with their doctors, and not with an overhang of some state legislators telling them what they need to do.
There was a similar approach, I think, by Justice O'Connor to the issue of affirmative action, which was an issue that arose in the early 1970s. I think maybe even in the same term as Roe versus Wade was the Bakke case. It was certainly within a year.
A few years later. It was a few years later.
2 years later. And the whole question of discriminating entrance procedures for universities, or in that case, it was a medical school. And that arose towards the end of her terms on the Supreme Court with respect to the admissions practices at the University of Michigan. And what was her approach in those cases for the law school and the university?
She was really tied in knots by affirmative action, and it was a hard thing for her to work through because she didn't want to just get rid of it altogether, but she was bothered by it. And she was bothered by racial preference. And she was kind of all over the place during the course of her decisions because in a couple of cases, she wrote the majority getting rid of government, saying that government set-asides. In the Richmond case, state set-asides for minorities. No, can't do it. Violation of the 14th Amendment and the Civil Rights Act. And then in the Adirondack case, also ruling that no, 14th Amendment says you can't do these set-asides. However, she left the door open because instead of saying, to use legal terms here, strict scrutiny, when you have a racial preference, you're supposed to apply strict scrutiny. And strict scrutiny usually means you can't do it. Strict scrutiny, you just can't do it. She left the door open. The legal expression was, she said, strict scrutiny is not fatal in fact. We sure look closely at it, but she left this little door open, and the little door wasn't all that little a door. So then the Adirondack case, even though the court appeared to rule against affirmative action and government set-asides in the federal government, in fact, the federal government kept doing it. And she knew that. She was sort of practical about it. But I think she was ambivalent about it, and it really came up to a head in affirmative action in higher education. In the case you mentioned, Michigan had two sets of affirmative action, one for undergraduates, where they said if you were a minority, you got a big break right away, 20 points towards 100 to get in. And she knocked that by 5-4. She writes the controlling opinion saying you can't do that. That's too much like a quota. It's too naked. However, with a law school where it was no point system, it was so-called holistic admissions. Race could be a factor among many, where it's vaguer and fuzzier. She upheld that. And so she split the difference. This is classic O'Connor. You split the difference. When it's too obvious in the case of undergraduate admissions, where there are points involved, no. But where it's vaguer and fuzzier, yes. Now, a lot of legal scholars were beside themselves about this because it's pretty fuzzy and pretty vague. And at the end of the Grutter case, she wrote, well, we expect that in 25 years, we won't need to do this. We're now in year 20 of that. And I asked her, one of the rare cases I got into cases, I asked her about this. And she said, well, that 25 years, I may have misjudged that. That could mean a number of things. One is, we need more time, we keep it going. Or in the alternative, I think I'm done here. My own personal gut guess, and this is just a guess, is that she would be done. That in this upcoming case that's coming before the Supreme Court, where there are questions whether Harvard and UNC can do racial preference and admissions. This is my guess, and it's no doubt colored by my own views on this, but that she would say, okay, we've tried hard enough and we're going to strike down racial preference. Now, the minute I say that, I'm sure 100 people who know her would say, no, she'd keep it going. I promise you, she'd keep it going. It sort of depends on your point of view on this. I will say the reason why I think that she would get rid of it is this. Her idea of affirmative action was to get to a colorblind society, was to have true integration. The whole point of this is to have the society come together as one. She did not like identity groups and identity group politics. And there's a scene in the book where she is taken by Kent Severud, who is the deputy dean, I guess, at Michigan. Former clerk of hers, into the basement of Michigan Law School. And there are all these posters for all these interest groups and racial interest groups. She hated that. She did not like victimization. She did not like strong racial identity. She just didn't like any of that. And that has gotten more extreme, not less extreme over time. And I think that she would bridle against that and want to reset the clock, so to speak. But this is my guess, because with her, it's really hard to know. She did follow the polls, I will say. On abortion, she thought, well, about a third of the country is against abortion no matter what. About a third of the country is for abortion no matter what, and about a third they're not quite so sure. That's about where she was in a way. And she would, she's not reading polling data, but she's sensitive to public views on big social issues. On affirmative action, she could see the polling is all over the place on affirmative action. It depends on how you ask the question. If you say quotas, people say no. If you say affirmative action, they say yes. And she was influenced at the end of the day by several things. One was at law school, she thought, should produce civic leaders. And she didn't like law schools having a very small percentage of African Americans. That just bothered her. Same thing with the military. Military officers need to look like the rest of the country. You need to have, if the country's 10% Black, the officers should be 10% Black. So that influenced her. And finally, businesses have had a lot of businesses back affirmative action. She was influenced by these briefs that would come in from these CEOs that were pro-affirmative action. So even though she had this resistance to racial preference, one of her clerks said she hated affirmative action, but she was the one who voted to save it. We'll take that for a contradiction. That sort of expresses her trying to feel her way through this extremely difficult social question, slowly, incrementally over time.
I think the racial identity is really more of a racial division. That's some identity. It's not, because she had a very clear Southwest identity and she appreciated that, but it's the divisiveness that
that's a better way
identity
to put it.
groups.
It's not the identity per se. It's that identity groups fighting with each other.
Yes.
And refusing to come together. That's what bothered her.
Well, that has been sustained. And in fact, it's all part of the current debate about what is the history of the United States in terms of racism, the legacy of slavery, the Harvard case that you mentioned that's coming up, the discrimination in that case allegedly is against Asian American students, not African American. This is a fact of life, and it's going to have to be something that will be addressed in these cases. Your references in these cases to former law clerks sharing opinions or being involved in some of this activity underscores to me that you had unusual access to her former clerks. I mean, she must have had about 100 of them during her.
I think 108 all told, if you count the ones that clerked for her after she left the court. I think the total is 108. And we interviewed 94 of them. Not all, they wouldn't all talk to us, but almost all did. Now, it gets a little complicated because she wrote them a letter asking them to cooperate. So they cooperate, but they're also under an obligation to the court, not just to her, but to the court. And they're human beings. So it varied. Some of them said, well, I'll talk to you about her, but I won't talk to you about cases. Others, well, no, I'll talk about everything. I'll talk about the cases too. Others were, I don't really want to talk to you about really anything. It varied. And fortunately, there are 4, every year she had 4 clerks. So there was usually one who would talk. And then we could go back to the others. But it was complicated. And I made an arrangement when I quoted these folks. I said that I won't, journalists generally don't do this when they're writing a story. But I said to them, Oscie and I said, if you speak to us, we will show you the chapter in which you appear. So you see the context. You'll see your quote and you'll see the context. So we did that. And of course, as you would imagine, someone says, oh, I didn't say that. And so you get into these negotiations, which are a little complicated. But I've learned from long experience in journalism that it's much better to show people what you're going to say about them. If you're going to stab them in the back, stab in the front, not the back. but show them what you're going to do and let them complain, because it's just sort of basic fairness. But more than that, you'll learn more. They'll engage. If you treat them with trust, they will trust you, and you'll engage. In the long run, you will learn more. So we sent chapters to all 94 of them who were, no, actually, we only quoted, that's right, we quoted maybe half of them.
Yeah.
Let's say 40 of them. We sent chapters to, and but we learned from their responses. And it's all, I think, except for maybe 1 or 2, it's all the whole book's on the record. There may be 1 or 2 cases where they weren't on the record.
I think it's worth saying that when she chose her clerks each year, she would interview them. Some of them would come recommended from sources and law professors she knew or other Court of Appeals judges. She always liked to have 2 women if she could, because she knew that being a Supreme Court clerk was a fast track to high positions in the legal profession. And her standard was not, are you ideologically this way, or are you ideologically conservative or liberal? She wanted them just to get along. She liked to have liberal clerks. She liked to have, one of her clerks was a civil rights activist. She liked to have people who were different. One of her clerks had swum the English Channel. One of them had been a boat person coming from Vietnam. She liked this. They were all going to be smart. She knew that. She liked something plus, like a smart plus. And then she liked them to get along with each other. Are you going? And if they didn't agree with her, would they write the opinion her way anyway?
Did she maintain social relationships with her former clerks as they passed on? Was this an entirely professional experience where everybody waves goodbye?
No. I mean, a couple of things. She was scary. If you meet her, she can be quite intimidating. I was scared of her when I first met her. She was intimidating, and a lot of her clerks were scared of her. She was tough and demanding and get your work done, no excuses. That's the way she grew up on that ranch. That's the way it was. But she was interested in their lives. She had this quality of when she spoke to you, you had her full attention. This word mindful, which not a word that she used, it's a more recent word, but she was mindful. She was able to focus on the moment. She wasn't distracted. She gave her full attention to you, and she cared about their lives. She worked them like dogs, but she really made sure that they showed up at their kids' graduation ceremonies, or, if somebody was sick, they could get home. And she was very attentive to that. And they were devoted to her. Not all of them. I don't think all of them had a perfect experience, but many of them were devoted to her. And that's one reason why they talked to us. They loved her. And
she would have reunions. And when they had babies, she'd send them T-shirts calling them grand clerks.
Yeah. We knew her feelings on homosexuality evolved. So she ultimately supported homosexual rights. But that was an evolution. And one of the ways the clerks knew is because she was asking, was it okay to send a T-shirt, one of those T-shirts to somebody, to a gay couple adopted a kid?
A gay clerk.
Yeah. Okay.
Yeah. Off the T-shirt goes.
Yes, off the T-shirt goes.
Absolutely.
You bet.
Did she tip her hand to her clerks on what she was thinking about cases? I remember reading in your book segments about sometimes she would have her clerks debate a case in her chambers.
Always.
But it sounds like they would do that, but they would have no idea how she was going to come out. Is that right?
Yeah. Kind of amazing. I wouldn't be able to do this, but of course I'm not like her in any way. But I couldn't do. She would keep a complete straight face and not tell them. They would fight it out, and they wouldn't know until she would assign the opinion, the draft, and then they would find out when she started editing their draft. But she didn't want to tip her hand. She was good about keeping secrets, or good about discretion. Discretion. She was a discreet person. Here's the thing, interesting. She liked to socialize. She did not gossip. Gossip is kind of the coin of the realm in Washington. That's what people do when they go out. And she managed to would not badmouth people. A lot of people say, I never do that. Of course they do it. But she did. She really did. The only time I ever was aware of her speaking less than flatteringly about somebody was about Justice Alito, her successor. She was not keen on him. I don't know exactly what happened, but he was, I think, a little chilly to her, and she was worried that he would overrule her or, go in a different direction. But that was a rare case, kind of almost a unique case of her letting others know that she was not 100%. She wasn't bad-mouthing him per se, but she just wasn't that happy with him.
Well, she seemed to use euphemisms. According to your book, she would describe somebody as attractive or unattractive, right? And we're not talking about a physical sense.
Well, but there's some ugly, attractive people in her.
Yes. And
it was a big
she was extremely indirect, but there are times when she would tip her hand about an opinion about an individual. I recall the episode or segment in your book regarding Justice Alito. He was her successor, right? I mean, he took her seat on the court.
She was very happy when Justice Roberts was appointed to succeed her.
Yeah, that was good. She liked
that. He was the first choice.
Yes, and then the chief passes away, so President George W. Bush changed his designation and made Roberts the chief and appointed
Harriet Mears. Well, Harriet Mears, there was another woman in between.
Yes.
So by the time they got to Alito, she was already on the court a lot longer than she planned to stay.
Justice O'Connor she'd announced her retirement in the summer of 2005 and thought she would be gone by the beginning of the next term, but had to stay on because of all of those appointment issues for her successor. And I believe was not formally replaced until January or February of 2006.
Right.
But in your book, there is a little segment about Justice Alito, and one of her comments was that he was Catholic, and there were too many Catholics on the court, right? And that was 5 at the time. Now I guess there are 6, are there not?
Yeah, that sounds like raw anti-papism, but it's let's break that one down a little bit. Her particular thing was that I mentioned earlier that she didn't like rules-based jurisprudence. She liked standards. And she felt the Catholics on the court tended to be more rules-based. That Alito, Scalia, Thomas, where they liked the Catholic missal, they weren't interpreting the Bible. This is the rule. And she felt the Catholics, at least the ones who came on the court, now obviously not Sotomayor, but the others were rule-based. And she used to tease, she had a Catholic clerk named Andrew McBride. She used to joke about this. He was a brash, funny, rules-based guy. And he was always trying to get her to join Scalia and on race and other issues, abortion, and she would fence with him, and he would tease her about this, and she would tease him right back because she was, even though she never gossiped, she could be blunt, and she was unusually blunt on this subject. She did say that we're too many Catholics on the court. That sounds all wrong, but if you understand it through the prism of the rule-based issue, it's more understandable.
Yeah, it was very interesting. Of course, I'm a Catholic, so I found it interesting. And I guess she made exceptions for Sotomayor and of course Justice Bill Brennan, the least restrictive Catholic in interpretation.
I'll say
he actually
the other side.
Yeah,
absolutely. He embodied the other side.
Absolutely. Well, the one remaining case that I did want to get your thoughts on, which is addressed in the book, which did have quite a significant impact on the dynamics of the court as well as an outcome of an election, was Bush versus Gore.
Yeah, tough case.
What's your reading of what went on there, and what was Justice O'Connor's ambivalence and views on that, and what was her incrementalism in that case?
Well, as you recall, because of the hanging chads and so forth, it goes to the Supreme Court, and what the Supreme Court did was they stopped the recount in Florida, and they did it by a 5-4 vote. And unfortunately, the 5 on the stop, which elected Gore, are all Republicans or conservatives. And the ones who wanted to keep the recount going, which might conceivably have elected Gore, were all Democrats. So it looks like naked politics. And that was troubling to her. She was with the 5. And this is a tricky story because 3 of the 5, Thomas, Chief Justice, and Scalia, are all want to do it on a narrow basis, that the Constitution says, Article 2, Section 1, the state legislature decides. And so therefore the state legislature decided that the Secretary of State had certified. So Bush wins, case over. And O'Connor felt, no, that's too narrow. The country won't understand. We need to find a broader basis for this. And she liked this equal protection argument that has subsequently been ridiculed because of probably bad law. But she wanted to find a broader basis, and she helped bring Kennedy on board. Kennedy was all over the place on this. As one of the judges told me, he was like a loose cannon on the deck. For a moment, it looked like he was going to side with the liberals using an equal protection argument to keep the recount going. And she brought him back to the Republicans, to the conservatives, using this equal protection argument one time only in this case. So the case has gotten a lot of abuse from legal commentators. Now, why did she do this? What was really going on with her? She did not like messes. She did not like messy outcomes. And Justice Ginsburg told us that her concern was the case would not get wrapped up. It would drift. If the recount kept going, it would go into January, and it would go to Congress, and there would be a huge mess. And in the end, Bush was going to win anyways, but only after a total mess where the country is having civil unrest and everybody's a mess. She wanted to end it, get it done, take the hit now, knowing that Bush was going to win anyways. And so it was a practical urge that she had. On the ranch, when the windmill breaks, you got to fix it in 48 hours or the cows start to die. And you fix it any way you can with whatever's lying around. And that was kind of her approach. She fixed it any way she could. It was inelegant. It took a lot of abuse, but she felt she was saving the country from a lot of duress to get to a result they were going to get to anyways. Now, having said all that, she took a lot of abuse for it. She didn't like it. She would change the subject. And over time, she felt regrets. As she did. She finally told the Chicago Tribune 10 years later, well, maybe we shouldn't have taken that case.
The Chicago Tribune had been part of a coalition of newspapers. There had been 3 media recounts of the actual ballots, which had been saved. And the Tribune was with the Wall Street Journal, the New York Times, Washington Post. They spent $1 million. They hired accountants. They hired people to count. And in all 3 cases, Bush won the electoral.
She would cite that. She'd say, hey, look, they did this several times and Bush won. So that was kind of a defense for her, but it was a defensive defense. She was not comfortable doing that. This made her unhappy to talk about this case. She didn't like talking about it. And she, as I said, I know she told at least one clerk that she's not a regrets person. That's not her. She said to me, you got to move on. The regrets don't do you any good. Her whole basis of life was about moving forward. Don't regret. Don't look back. Decide the problem and move on. But that was hard for her in this case.
Well, you refer to the 5-vote majority in Bush v. Gore as Republicans in the sense of being appointed by Republican presidents. I do want to just point out that 2 of the 4 on the other side were also appointed by Republican presidents, Justice Stevens, Justice Souter. But of course, during their ascendancy to the court, they wound up being liberal justices. So I think the terminology is probably better, conservative versus
better.
It is, yeah. You're right.
I want to add that to Al Gore's credit, after that decision, he conceded with quite a gracious speech. And that's relevant because that didn't happen in 2000.
Yeah, and I think it's particularly
2020
significant because the vote margins was so much closer in 2000. We're talking about fewer than 600 votes in the state of Florida. So that really was incredible, that entire episode, and the willingness of then Vice President Gore to concede finally that race.
And avoid any contention when January 6th rolled around.
Yeah, although it did trigger years of examination about the voting process and the recount process. We thought we were solving those types of instances, but obviously we still have a lot of work to do in light of the outcome in 2020 with even multi-million vote differences. Let me ask a question that's sort of overarching about Justice O'Connor and your book, which is entitled First, which signifies that she was the first woman to be on the Supreme Court. Historically, after all these research, all these interviews with her colleagues on the court, law clerks, and many, many other people, do you have an opinion as to what else she might be remembered for historically, other than being the first woman on the court?
She was, Jan, let me just propose that, yes, she was the first woman on the court, but by having her on the court, it encouraged law firms and corporations to hire more women. It really helped open the door broadly to women in the law. And now I think women are half the law school classes in the country, but that happened sooner because of her. And that's an important legacy.
And the way she comported herself. I mean, she used to say, it's good to be first, but you don't want to be the last. She knew that all the lights were on her, all the cameras were on her. And she comported herself in a way that is, I think, her true legacy, that she was a decent person who believed that you should behave honorably with each other. And she believed in not only the rules of democracy, which she carried the Constitution in her pocketbook, she believed in the unwritten rules of democracy, that you should treat people with comity and amity and decency and listen to them and be willing to compromise. And that our system the laws only work. She said something about the Constitution only works if the people are behind it. And she was a living role model of how you deal with complex issues by listening and by being patient and by listening to the other side and treating them with decency and respect. And, one time when she felt that the House and the Senate politicians were fighting with each other too much, she got the majority leaders of the House and Senate, I guess it was the majority leader of the Senate and the minority leader, dash one lot in her chambers and lectured them on civility. Come on, you guys, be nice to each other. And they kind of bridled at this. Lott wouldn't even talk to me about it. And Dasher was kind of, what the hell's going on here? But that shows you how much she cared.
Well, I don't deny any of those aspects. As somebody who graduated from law school in 1973 in a class of 140 students and only 4 of whom were women, I appreciate what has transpired since that time. And to the extent that the justice was an inspiration for additional women to go into law school, which she clearly was, as was Justice Ginsburg, I might add. Yes, they were part of the transformation, not only of law schools and the legal practice, but of our society. What I was looking for in asking this question was more jurisprudential. Justice Brandeis was the first Jewish member of the Supreme Court. But he is known for many of his memorable cases. He was an exquisite writer. He is the one who came up with several notable terms and expressions and observances, such as states being the laboratories for development of laws and things of that sort, and of rights. And I think that what struck me in reading about Justice O'Connor is that, as you've already noted, she was dry and factual in whatever she wrote. She didn't want to turn a phrase, and certainly not a phrase that would be ridiculed, such as we got to wait 25 years before we don't have affirmative action anymore. Was there anything you think in her jurisprudence that will be of significance and long-lasting?
If there's a phrase that may be, depending on the course the country takes, quoted in the future, it could be that the state of war is not a blank check for the president. That's the Hamdi case. And if this country ever finds itself in a state of war, that will be something that you'll see again.
Yeah, that was a rare time when she did turn a phrase. She also, in a lesser thing, in that FERC case, she said the states are not supposed to be something for the federal bureaucracy,
laboratories.
I forget test cases for that. I'm going to botch this because I can't remember the phrase, but it was a phrase that gets quoted in when people talk about federalism, keep the feds off our backs. So that's a minor example. The larger point is that she did not turn a lot of phrases. She did not have she resisted the idea of a judicial philosophy. So you could say that her impact was evanescent, that it was destined to pass because she didn't lay down clear markers or milestones or memorable phrases or precedents. On the other hand, she wielded a hell of a lot of power. She was a decisive vote, I think 220 times, something like that. That she wrote the law of the land on affirmative action and abortion for 30 years. That's not a short period of time. But I don't think she's not going to be remembered for a judicial philosophy. She isn't. If she's remembered, she will be remembered for being the first and doing it in a way to make sure that there would be a second, third, fourth, fifth, et cetera. And for her attention to something that is sorely missing in our civic life today, which is civility. I hope people will remember that once upon a time, there was a very powerful person, the most powerful woman in the United States, who really worked hard on being civic-minded and civil with others, who understood that democracies don't work very well unless people try to actually listen to the other side. I fear that side of her will be forgotten, but Oscie and I wrote a book hoping that people will remember her for that.
Well, your book, I highly recommend. I've read it. I've enjoyed it. I've dog-eared it. That's how I'm able to ask some of these questions. And I commend it to our listeners. First, the biography of Justice O'Connor, by Evan Thomas and with the help of Oscie Thomas. And last time, as you know, I always seek a book recommendation from my guests. When Evan was on last time, he recommended John Meacham's book, which has just come out on, what is it, Something in America?
Soul of America.
Yes. And, just weeks after that recommendation came out, there was John Meacham meeting in the White House with other historians to advise President Biden on history and the state of democracy and foreign and the U.S. policies. So I will ask each of you if you have a book recommendation today for our listeners.
My favorite new book is called Becoming FDR.
Oh, that's
by Jonathan Darman. About, FDR has been written about a lot, but Darman went back and looked at the effect of polio on FDR and how it made him more empathic and just a much better leader. It's a beautifully written book and very revealing about our most important leader.
Evan and I didn't talk about this ahead. That is my choice. So let me double down on Becoming FDR. Was out last month. John Darman.
I'm familiar with Mr. Darman, and
I know.
I haven't read his book, but I'm going to put it on my reading list. Thank you both, and thank you so much for your time and for your insights today on early returns. Thank you for coming, and thank you to our producer Jody Mayer Piazza for putting this program together. And I hope our listeners will be back with our next guest in about a month.
Thanks, Jan.
Thanks for joining Early Returns, Law and Politics with Jan Barron. We hope you will join us for future episodes, which will continue to bring you voices and insights from the people engaged in our political landscape.